Good morning, everyone. We're going to go ahead and get started just to make sure we're keeping ourselves on time here. This is the next session on disability claims, leaves, and accommodations. Thank you so much for coming this morning. I'm going to first let Marilyn Clark do a brief introduction of herself.
Good morning. My name is Marilyn Clark, and I'm a partner in our labor and employment group here at Dorsey. I'm a Dorsey lifer. I've been here since I was a summer associate back in 2005. And I am a self-proclaimed statute nerd, so I love all of the complex intersections of the various leave laws. And I also served on a secondment for one of our larger clients, so I have some insight into what the view is from the client's perspective. And we tried to put together some materials today that really get at the heart of some of the thornier issues that I saw on a day-to-day basis, and I'm sure you all see on a day-to-day basis.
Great. And my name is Tim Goodman, and I'm a partner in the Benefits and Compensation Group. If you've looked at the materials, you'll see we have over 50 slides in 50 minutes. And so we'll start talking about this fast, so please take notes very quickly. Anyways, we're actually, some of the slides we have in here just for reference and things, and we'll note when we might skip over a few of the scenarios or examples, but we thought you'd still be interested in them. But with that in mind still, we'll go ahead and get going. We're going to start a little bit with disability claims themselves. And leaves and disability claims are sort of this whole intersection. We've got all these different laws coming together and all these different rules, and so that's why we thought this would be a useful session. First of all, just thinking about what plans are subject to disability claims, and I have a little bit up here about ERISA plans and which plans may indeed have something to be done with disability claims. Most people don't necessarily think of it, but a fair number of retirement plans actually have disability claims provisions in them. Even with like a 401k plan, you may see that if someone becomes disabled, their vesting is accelerated, so they become fully vested, or that they might be able to go ahead and take a distribution because of becoming disabled. Obviously, disability plans is a place to find disability claims, but then there's also non-qualified plans. And again, non-qualified retirement plans is another place you will see these kind of claims. Basically, if the plan is subject to ERISA, you have to have disability and other claims procedures in the plan to go ahead and be followed in order to be compliant with ERISA. And why am I talking ERISA? Well, it's because recently, in a sense, the DOL went ahead and updated the rules with how to address disability claims. And there's some notes here in terms of when the guidance was issued, but basically these new disability claim procedures are much more complicated than what I'd say were the old disability claims procedures. In looking at the slides here, and I think we're on slide number 22, at least at the bottom right-hand corner, you'll see ERISA's new disability claims procedures were proposed in 2015. They were finalized in 2016. They were actually supposed to be effective as of January 1 of this year. That date was pushed back to April 1st. April Fools, I guess. And basically, the big difference with these is if you are a plan administrator and you're making the disability determination, that's when these claims procedures kick in, because that's when the Department of Labor is concerned that there's this conflict of interest that you have in determining whether or not someone is disabled. On the other hand, if your plan document instead refers to some other decision maker, so let's say you say under your 401k plan, if you're disabled under the company's long-term disability plan or is decided by the Social Security Administration, then you can get these disability benefits. That takes you out of the conflict of interest, right? You're not the person who might have a motivation for denying the accelerated vesting or the payment out of a distribution. So that's one of the big things here. Some of the additional things you have to do if you're the person who's making the decision on whether or not someone is disabled. And this slide here, slide 23 in the lower right corner, just notes these. There's additional notice and disclosure elements, including additional information that has to be in denial letters, a discussion of the decision, and also a requirement that any notice be in culturally and linguistically appropriate notices. There's also some process enhancements in terms of determining the disability. You need to really assure the independence and impartiality of those claims adjudicators. And you need to have very strict adherence to the claims rules, otherwise you risk having the claim being viewed as denied and then deemed exhaustion, and the person can proceed directly to court. So I'm not going to go through these in a great deal of detail, but you can see from the next 2 or 3 slides some of the things that you have to do that under these new claims procedures. There's additional statements about the ability to receive information and copies of documents and records, even at the claim level. You have to provide additional basis for disagreeing with or not following the views of medical or vocational professionals, because oftentimes what you have is if a person says they're disabled, they may have seen their doctor, and their doctor says, oh, they're disabled, and they're not doing well, and then you have your person look at them. Well, if that's the case, you get into this sort of conflict going back and forth, and you have to spend much more time explaining why you're not crediting certain evidence in terms of the disabilities. The culturally and linguistically appropriate notices, this is something we're seeing more under the Affordable Care Act and elsewhere as well, and so of course this is something that's in these regulations as well. And again, it's where a claimant resides in a U.S. county where 10% or more of the population is literate in the same non-English language. But, and I'm jumping too far there. What does this mean for you? What I would say it means for you is this. If you have a retirement plan, especially, or a non-qualified plan, you're going to probably want to look at what do your disability claims procedures provide for, and you may want to consider, is there a way to revise those procedures? If you have, say, a 401k plan, and it says you're the decision maker, either A, that plan will have to be amended at some point in time to then bring the disability claims rules up to speed with the new requirements, or B, you may want to say to yourselves, do we really want to go through all this? Should we maybe just limit disability to when somebody else has made the determination and base it upon that? With respect to your long-term disability policy, you're probably going to want to just double-check with your carrier. I'm sure that they are going to go ahead and have updated their practices, but you could always double-check with them and see if they will be producing SMM or anything in terms of the revised claims procedures for the long-term disability policy. For short-term disability, usually that is not necessarily an ERISA plan. And I say that because under the earlier slide, you'll see that short-term disability is under the salary continuation exception that's under the ERISA regulations. With that, you might not have to make any changes, but again, if you use the same entity to determine your long-term disability claims and your short-term disability claims, you know, maybe a change will be made anyways in terms of how those claims are looked at. And so again, it's worthwhile to talk to your carrier about what they might be doing with these new claims regulations. But with that, I'm actually going to turn it over here now to Marilyn so she can talk about some other laws, and we can then talk a little bit about the interaction of all these.
Thank you, Tim. So we're going to look now at the range of leave laws that apply to employers, and of course we can't dissect each and every one of them in great detail, but we want to talk with you today about the ways that statutes such as the Family and Medical Leave Act, or the FMLA, the Americans with Disabilities Act, or the ADA, workers' compensation laws, city sick and safety time ordinances, the way that all of these various laws overlap and intersect, and some of the thornier issues that employers need to sort out when addressing employee leaves in these various contexts. So we have a couple of slides that give a basic overview of these statutes. I want to talk to you about some of the stickier points to call them to your attention and make sure that they're on your radar. The FMLA, of course, affords employees 12 weeks of leave in a 12-month period. The 12-month period is up to the employer to determine. It can be a rolling forward, a rolling backward, a calendar year, or any 12-month period determined by the employer. The key issue is that the employer needs to communicate what 12-month period they've selected to the employees. If they don't do so, it's up to the employee to select the 12-month period most beneficial to them. So if you don't have a policy that outlines what 12-month period you've selected, you can have a range of employees that each have a different period in question, and the administrative burden can be a nightmare. So just a note to make sure that you're communicating that choice. The FMLA affords leave on a block or intermittent basis. We're going to talk about some of the thornier issues that arise in the intermittent context. And we're also going to talk about medical certifications and how they can really work to your advantage in managing the leave process. The FMLA protects employees from interference with exercising their FMLA rights. So that means employers can't deny employees their right to leave when they have an FMLA qualifying reason, and they can't use leave taken for FMLA purposes against an individual. Now, one of the stickier issues that can arise in this context is whether the reason for the leave qualifies for FMLA, and how to handle issues when an employee is coming forward and saying they need leave and states that the underlying reason is for a condition that you as the employer believe qualifies for FMLA, but they don't want to take FMLA time. And under existing law, employers are permitted to designate time as FMLA and treat the leave as protected and start counting off the days against the FMLA allotment. And the important part is to make sure that you're doing your due diligence to ensure that that underlying reason is indeed FMLA qualifying. The Ninth Circuit has come out with one decision that suggests that if an employee declines to have the time allotted as FMLA, the employer might be prohibited from treating it as such, leaving it up to the employee's election. But the majority of states and the majority of the commentary out there considers it up to the employer to designate FMLA leave time if they have sufficient information to understand that the underlying condition is qualifying, and in fact that they might have an obligation to do so to ensure the leave is treated as protected. A brief refresher on the ADA. The ADA prohibits employment discrimination against a qualified individual on the basis of a disability, and here the definition of disability, of course, differs than in the ERISA context. And as some of you may recall, back in 2008, amendments to the ADA broadly expanded the definition of what qualifies as a disabling condition. So as a general rule, we tend to say that a deep inquiry into whether somebody is disabled is not worth putting your time into, treating conditions as likely qualifying as a disability unless they are clearly short-term in nature, clearly outside the scope of anything that would constitute a long-term condition, is the best way to proceed. Employees must also be qualified to be protected by the ADA, and that's a piece that sometimes gets overlooked as a substantial tool that employers can use to ensure that they are holding their employees accountable and ensuring, again, that as they're trying to manage the leave process, they're not doing what we like to call the good deed that certainly will go punished. For example, if an employee is unable to perform the essential functions of their job, the ADA does not require that as an accommodation employers carve back the position such that they're only performing a handful of the basic duties that they're expected to perform. Employers also aren't expected, as a general rule, to go searching for an alternate position for the employee, although if there is an alternate position available that the employee is able to perform, that may be an adequate accommodation. And in my time on secondment, this was an issue that cropped up again and again where managers would have employees coming in and saying, well, I've injured my leg or I have an issue with my shoulder, so I can only perform these limited tasks in my job, and the manager would let that employee essentially create a new job for themselves without any documentation from their physician. And over time, the employee became accustomed to the job and then felt entitled to that position, and it became a challenge to roll it back. So right at the outset, if somebody comes forward with a qualifying reason for a leave, either under the FMLA or the ADA, looking at the scope of what they're able to do and ensuring that if they can't do the job, that you're offering leave as an accommodation rather than carving back the job itself. A quick refresher on the workers' compensation wrinkle.
Can we ask questions in the middle?
What?
Would you want us to? Okay. So I'm just curious if you have any thoughts on where I get stuck on assuming that somebody has something that would qualify under the ADA, but they don't maybe know or tell you that they're not saying that they do and that they need an accommodation. So then am I regarding them as having something if they have ADD or something that they're describing, and I'd say, okay, I may be familiar with that. I'm thinking you have this, but they're not saying they have this, and then do you know what I'm saying? How do you address that?
I do. So the question is, how do you address a situation where an employee is coming forward and requesting leave as an accommodation and is giving some detail that suggests they may have a disability but isn't coming straight out and saying it? Employers are on notice that an employee may have a qualifying condition under the ADA or the FMLA where the employee provides sufficient information for them to understand that there may be an underlying condition there. And my guidance, if you don't have if the employee doesn't come right out and say what their underlying condition is, if they're just asking for time off and they're being very vague, it's probably not best to dig in too deeply and ask about a disabling condition as a matter of course. But if they start to talk about physical or mental health conditions, you're likely on notice that there may be a qualifying condition there. And then you're required to engage in an interactive process. And again, if the employee is requesting a lengthy leave period, the first order of business, if they qualify for FMLA, would be to give them the FMLA paperwork. If they don't qualify for FMLA, then to start engaging in the interactive process to understand how much leave they're going to need, and then you start to get into the certification process. So again, the triggers would be any information about a physical or mental health condition, or for FMLA purposes, conditions related to family members. And once you have that information in front of you, then it makes sense to go down the path of raising that inquiry. I also encourage employers to make sure they're separating out the leave process inquiry from direct level supervisors. So if training supervisors to understand what that language means and then to send the employees over to HR or to another internal person who's designated to manage the leave process is a critical aspect of avoiding potential discrimination claims down the road. You don't want your frontline managers and supervisors gaining detailed information about underlying health conditions, which the employee can later say, you regarded me as disabled. So that regarded as question can be mitigated by making sure you're keeping the processes separate and the supervisors aren't gaining additional information that, again, the employee could later use to claim was the grounds for discriminatory employment decision.
Mainly it comes into play with more of an accommodation than a leave or a disciplinary issue, that the supervisor's disciplining them, but then they're telling me what the employee said to them, and I'm like, okay, well, tell me exactly what they said to you, because it sounds like they're saying something that is protected that you can't discipline them for.
Sure, and the issue of discipline, it gets a little bit thornier. We've got some scenarios that are going to address that, and the question was, how do you ensure that supervisors aren't looking to discipline individuals when they're seeking leave and they've raised information that might suggest the leave is protected? So in the interest of time, we're going to move forward and try to get through the material. Those are very good questions, though, and hopefully the scenarios will answer them. And Tim and I will be available afterwards to answer any individual questions that come up, because we know there are probably a lot of them that arise in this context. So a quick workers' compensation refresher. The workers' compensation statute here in Minnesota and in most states provides the exclusive remedy for on-the-job injuries. Now, what that means is that the workers' compensation paradigm and structure provides the remedy in terms of compensation to the individual for the injury. Again, we need to bear in mind that workers' compensation is an insurance-based program, and again, provides coverage for employees who are injured and compensation for losses they may suffer. Because what workers' compensation is deemed an exclusive remedy, employers often get confused about how that interplays with the FMLA, the ADA, and other protected leave statutes. Those statutes also come into play where the underlying condition necessitating a workers' compensation coverage also qualifies for FMLA or for ADA. So if an employee is injured and it's a temporary injury, they have a broken leg, something of that nature, FMLA and ADA would not come into play. But if the employee is injured in a way where they have a chronic condition or they have a serious condition, a broken leg would likely qualify for FMLA purposes, not necessarily a disability for ADA purposes, then the statutes would run concurrently. So again, if you have enough information to understand that the underlying condition qualifies for FMLA, you want to start tracking FMLA concurrently with workers' compensation so that you don't end up at the end of a workers' compensation coverage period with then the employee coming back 2 weeks later saying, now I have another serious health condition and I'm entitled to an additional 12 weeks of time off. And this is a key point in understanding how all of these statutes dovetail and interact together, making sure that your policies clearly lay out what types of leave will run concurrently and referring from one policy to the other so that employees are clear that all of the policies will run together when the underlying condition warrants doing so. Oftentimes, what I see when we're doing handbook reviews are siloed policies where each separate type of leave is addressed in its own individual package, and there's no language tethering the various leave policies together. So again, on the front end, by making sure that you're communicating clearly to the employee what your expectations are, you can save a lot of trouble on the back end trying to sort out how all of these various types of leave are going to run together. Whenever you have underlying conditions that run across statutes, you can have the leave run concurrently. And of course, there are going to be areas that don't intersect where employees might have reserved time under one policy or statute that doesn't qualify under another policy or statute. But you want to make sure you're tracking carefully and marking off what falls into each bucket so that you're not ending up with multiple opportunities for leave that can pile on top of each other and result in an employee you never see. So jumping into state and local sick leave. So this added wrinkle has created a lot of questions for our clients, and there is a lot of detail here, but I'm going to go through some of the basic highlights in the areas that we've received the most questions. So the sick leave ordinances went into effect on July 1 of last year, so they've been in operation for just about a year, and they apply to all employers with 6 or more, to all employers. Those employers with 6 or more employees need to offer the leave time allotment on a paid basis. Those with under 6 employees still need to offer the time, but they don't need to do so on a paid basis. The ordinance applies to full-time, part-time, and temporary employees as well as paid interns, so covers pretty much everybody. And both the Minneapolis and St. Paul ordinances provide that employees will accrue 1 hour of leave for every 30 hours of work with an annual cap at 48 hours and a total cap at 80 hours. So that means that leave does roll over from year to year, and that process is one that employers can manage either by granting an allotment on the front end at the beginning of each year. So in the first leave year, they would grant 48 hours, but then each year thereafter, you can grant 80 hours to make sure you're covering accrual and rollover, or you can calculate on an accrual basis as you go forward. The leave may be taken for a range of underlying factors, some of which overlap with the ADA and FMLA, some of which do not. Some employers choose, instead of granting the leave allotment under the sick and safety leave ordinances at the beginning of the year, granting a general PTO allotment at the beginning of the year to cover a range of conditions. And as long as that PTO allotment affords the same or more benefits as under the ordinances, and as long as the employer allows PTO to be used for the same underlying reasons, having a policy that just generally grants a pool of PTO will satisfy the ordinance requirements. It's interesting to note also, this has been a question that has come up for a lot of our clients, that an injunction still remains in place against enforcing the ordinance against employers that do not themselves reside within the municipalities of Minneapolis or St. Paul, but who have employees who work within those municipalities. And we anticipate that provision is likely going to stick and will be codified into the ordinances at some point. But just wanted to call out that as things stand now, simply because you have somebody who works in the city doesn't mean that you need to afford them sick time if your business isn't located in the city. We have a slide that shows the prevalence of these statutes, where we're seeing them pop up across the country. And we wanted to note that there are also multiple states, including our own, that are pushing back against these ordinances and seeking to have them preempted by state law to create some continuity for employers. And the goal here is to ensure that employers aren't subject to a myriad of varying laws in multiple contexts, and that at least ensuring on the state level, there's the opportunity for states to say, this is the standard we're going to hold you accountable to, and not allowing municipalities to create this network of laws that are impossible to manage. And again, the takeaway here is that employers can have a range of options for how to enforce or to ensure they're complying with these policies, or rather ordinances. They can either go the state-by-state route, understand what obligations exist in every different state and every different municipality that might impact you, or to offer a broad PTO program looking at the most generous obligations out there that are applicable to you, and managing it in that way. Some other laws to bear in mind: military leave laws, voting and jury duty leave laws, Pregnancy Discrimination Act. There are a range of other statutes that also provide for leave that you need to bear in mind. And again, thinking through on the front end and how you implement your policies to make sure that you're looking at where there are areas of intersection so that you can manage the entire network in the most efficient way possible is a good practice to follow.
So just to confirm, you're saying that the broad PTO plans are sufficient for the other states as well?
So the question is whether broad PTO plans are sufficient to satisfy sick leave ordinances that are cropping up in other states as well. As a general rule, and I have to say I have not deeply studied every single ordinance, but as a general rule, as long as employers are offering a PTO program that offers more than the minimum pool of leave that's required under the ordinances, and as long as they're following related accrual and carryover practices and mandates under those ordinances, and as long as they're affording PTO for the same underlying reasons as the ordinances provide, that should be sufficient.
Great, and now we turn back to benefits for a moment here, now that we've had that nice overview. When someone does go on leave, it raises a number of benefit issues then, of course. You have health plan issues in terms of continued coverage, COBRA notices, and also hours counting for the Affordable Care Act. You know, it's interesting, I actually did a survey at a different seminar. Has the employer mandate been repealed? And for those of you who don't know, the answer is no. The individual mandate has been repealed as of next year. The employer mandate is still alive and well, and the IRS is actually sending out notices, so we're not through with that yet. But obviously, under the FMLA, there's some protections in terms of health plan coverage, and you have to take that into account too, in terms of thinking about how individuals might pay or when they might pay for their health plan coverage. So when somebody is going on leave, you have a lot of different issues just in terms of even just your health plan. When somebody's hours, let's say that they're no longer covered by the FMLA and their hours have been reduced, that can of course be a COBRA trigger there when their hours have been reduced such that they are no longer covered by the health plan. So there's lots of things to think about there, but that's not where you stop either. You know, with your retirement plan, there's different issues that'll come up, such as loans. Obviously, if a person, and this is where some of the interaction, we haven't talked about like short-term disability pay or other things, but if someone doesn't have short-term disability pay, if they're on an unpaid medical leave of some type, at some point their loan is probably going to go into default if they're in a retirement plan and they have a loan. You might also have issues in terms of, under the retirement plan, there's rules about crediting service for people who are on leaves there as well, and is that service properly being credited? In terms of also, that I talked earlier about the full vesting or distributions upon disability. So some other companies, in addition, on short-term disability, have people come up to them and say, is there a way that you have this nice short-term disability program? Can I supplement that with the PTO I have so that I'm actually not just getting 60% paid during the next few weeks? I've built up a bank of PTO, and how do I work with that? So when somebody comes to you for one of these leaves, there's a lot of different benefit issues that come up at the same time that you're also trying to say to yourself, are they covered by FMLA? And if not by FMLA, do I have an ADA issue? And is this a workers' comp issue? And you have this nice interaction between both the employment laws and the benefit issues. I'm not going to go through this next slide in depth here, but you know, military leaves now are not as common now as they may have been a few years ago, but they still occur. And they raise similar issues, but also additional issues because of the additional protections under USERRA. And so you have to work through those as well if someone comes to you on some sort of a military leave basis. With that, I think we're going to try and turn it over to some scenarios where we can walk you through some examples.
So the first issue we're going to delve into is notice, and this comes back to the question that was raised earlier. How do you know when an employee is seeking leave or entitled to leave under the FMLA, the ADA, or some other statute? What constitutes adequate notice to the employer? So an eligible employee is required to give notice to their employer 30 days in advance if they have a foreseeable need for leave and if they're seeking benefits, or as soon as reasonably practicable when leave is not foreseeable. And they also have an obligation to give timely notice that a past absence was for FMLA reasons or other qualifying reasons if they're not able to, if they're not aware of those reasons in the first instance. As I mentioned, however, employers are often on notice that an employee is entitled to benefits even when the employee themselves isn't articulating a specific request for leave. And in instances where you have that notice, employers can step into hot water if they're moving forward and enforcing general attendance policies and other employment adverse actions against an individual that is somehow tethered to their leave when they have sufficient notice that a leave may be protected. So the first scenario is one that I've seen crop up with multiple clients over the years, and this often comes at the supervisory level. And this is called this scenario is called the AMSIS excuse for termination. And this is a scenario in which you've got a problem employee, somebody that's difficult to get along with. They do their job generally well, but they're just a real pain. Folks don't like to work with them, folks complain about them, and then you have a manager or a supervisor who's really reluctant to dig in and address the performance issues with the individual because that's an uncomfortable discussion. Then you have that employee who eventually decide to go out on leave for some reason, and the supervisor thinks, aha, we've got an attendance policy. It's black and white. If the person isn't abiding by our attendance policy, that's a good enough reason to get them out the door, and then I don't have to address the thornier issues with the conduct. And in this scenario, we have somebody who fits that bill, suddenly has an issue where they communicate to a manager that they've got a severe pain, they're suffering from some physical condition, and they need to leave. That person then doesn't show up for a couple of days, and the supervisor says, oh, you're out of here. Under our policy, that's a job abandonment. You didn't call in, so you're fired. Well, as you can imagine, there are cases that have dealt with this issue because it comes up quite frequently. While employees are required to give some notice to the employer that they're seeking leave for a qualifying FMLA or ADA reason, under the FMLA, written notice is not required, and same for the ADA. There's no formal requirement that an employee submit forms in advance to tell the employer that they have a need for protected leave. Regulations require only that they provide verbal notice sufficient to make the employer aware that there may be an underlying qualifying condition. So coming back to the question that was raised earlier, if an employee is talking about any physical or mental health condition that is underlying the need for leave, or even just saying, I need to leave the office, I need to leave for the day, and then not showing up. If you have noticed that individual was leaving due to some physical or mental condition, then that might be sufficient to put you in the hot seat to ensure that you're getting them FMLA paperwork if they qualify for FMLA, engaging in the interactive process if they might qualify as a disabled individual. And we have another scenario that we're not going to dig into too deeply just in the interest of time, but I wanted to add here that employers can be on notice even if the employee doesn't articulate that they have a physical or mental health condition, but their behavior suggests that they do. And an example would be an employee who has worked for you for multiple years, has always been a reliable person, a good performer, and suddenly they start behaving in a bizarre fashion. One case that addressed an issue of this nature involved an employee who had a long history with the employer, always received good performance reviews, and then suddenly started falling asleep at her desk, was behaving in a bizarre manner in the office, saying odd things to her coworkers, and then suddenly disappeared for a couple of days. And the employer moved forward and terminated her for not showing up to work, and a court found that the behavior itself was sufficient to put the employer on notice that she may have a physical or mental health condition that was serious and qualified her for either the FMLA or the ADA. So general practice tips. As a general rule, avoid relying on absences that potentially arise from medical conditions as grounds for dismissal. If there is any information that comes forward, again, about any physical or mental health condition, move into, again, shepherding that employee to the proper people internally to discuss FMLA, ADA, or other potential protected leave opportunities. Ensure the managers are sequestered from that process so that when the individual comes back, they can resume oversight of their general work performance without risk of a discrimination or retaliation claim. And make sure also that you're applying those policies evenly and equitably. Employers can hold individuals who are on protected leave accountable for call-in requirements, again, provided that it's reasonably practicable for the employee to meet those obligations. So if an employee is out on FMLA leave, or especially on an intermittent basis, you can hold them to a standard of calling in advance of their shifts so that you can plan for business purposes. And again, unless there's something that physically prohibits the individual from doing so, if they fail to meet those requirements, you can move forward with discipline on that basis. But you want to make sure you're, again, enforcing those policies equitably. Sometimes where you have somebody who's out often on leave for a physical or mental condition, supervisors get frustrated with that person, and where they're a little bit more lenient with somebody who hardly ever takes leave, and oh, they didn't call in today until 2 hours after their shift started, but they're usually reliable, then they crack down with a hammer on the person who's under protected leave. That disparate treatment can be grounds for a claim. You want to make sure that you're addressing performance issues promptly and directly. Don't wait until a leave issue arises to then start discussing performance. That's another issue that happens. Even if you don't enforce attendance policies against the individual, once they've taken protected leave, if then you get the supervisors or managers get frustrated and say, well, now we're going to start hauling in all this other stuff that we've been grinding our teeth about but not discussing for years, that starts to look like retaliation. Make sure that you're treating everybody equitably. Don't treat problem employees differently than others with respect to the leave context. And then ensure that your attendance policies have carve-outs for protected leave. There are a lot of no-fault attendance policies that employers like to implement these days, and you need to be very mindful of tracking what leaves qualify as protected leave, again, especially in those instances where you're on sufficient notice that the leave may be protected, instead of just marking ticks in the boxes without being aware, and then suddenly finding yourself at a disciplinary stage under a no-fault policy, and then learning, well, gee, we had all this information that some of these absences may be protected. So I'm going to skip through the next couple of slides and jump ahead to the intersection between the FMLA and the ADA. This is slide 48 in your packets. So in this scenario, we're going to talk about where the FMLA ends and the ADA begins. So we have an employee who started working for her employer after she already had chronic back pain and a back condition. She was promoted steadily, and after working for the employer for multiple years, she was diagnosed with a serious condition and underwent surgery. She took FMLA leave, but on the last day of her leave, she underwent a second surgery that would keep her out for a lengthy period of time. She asked for extended leave. The company said no and terminated her employment, inviting her to reapply for work after she was medically cleared. This was, and in this scenario, her FMLA had been exhausted by the first leave. So she doesn't reapply, she sues under the ADA. And as I'm sure you all are aware, when FMLA ends, employers do need to consider other protected leave options such as the ADA. Where employers sometimes get into a thorny issue in looking at the ADA issue is if the leave is lengthy that the individual is requesting, sometimes there's an immediate reaction that, gee, we just granted all this FMLA leave, now they're requesting a lengthy leave under the ADA. We don't have to continue to accommodate them indefinitely, so we're just going to say no. And courts agree that endless leave is not a reasonable accommodation, but the key here is ensuring that you're looking at each individual circumstance on a fact-specific basis. You need to be looking at the individual facts and circumstances of each individual request for leave. And an important component of that consideration is the nature of the employee's position. For some high-level positions or positions that involve a lot of institutional knowledge, lengthy leaves can be very disruptive to the employer's business, and there are good grounds for arguing that the leave would constitute an undue burden. I'll note that the bar to show an undue burden is high, and of course the obligation is on the employer to prove that defense, that the leave requested was an undue burden. But the more, again, institutional in nature the position is, the more likely the employer can argue that an extended leave would be unduly disruptive because they need somebody in the position who understands the business, and so on and so forth. Positions that can be easily filled by a temp agency, that sort of thing, can require very lengthy leave periods. So you want to make sure that you're digging in and looking at any request for leave on the facts underlying the specific circumstance, and then also recognize the obligation to engage in an interactive process. Even if the leave might be unduly long and impose a burden, you nonetheless need to engage in an interactive process to understand what the nature of the leave the individual is requesting is, whether there are alternative accommodations that might help the individual come back to work sooner, rather than just saying we flat out can't accommodate this leave and you're fired. Dig in and figure out whether there's some way to bring them back sooner if you don't think you can accommodate the leave. And again, make sure that you're documenting and recording that process in case the decision is ever challenged.
Before you jump to the next scenario, real briefly, one other thing I was going to mention, going back into the benefits world, is sometimes I get questions about, well, is what the employee is saying here PHI, or what concern should we have about these medical conditions and information that is being shared? And that's a very valid question. If the employee themselves is providing you with information about their situation, I have a pain in my side, I have a really sharp pain in my side, I have pneumonia or whatever, that is not protected health information. That is not coming from your employer health plan. On the other hand, it's still important to treat that information as confidential information. Almost every single state has privacy laws. And so again, earlier Marilyn had commented on, at some point, it's probably better in many ways to have the HR area take over the handling of these situations. And that's probably also a good reason also for respecting the privacy of the individual and making sure that that information doesn't somehow get discussed amongst their coworkers in terms of, oh, you know, John is out again today and he still has that sharp pain in his side or whatever it is. And, you know, it's one of those things where you want to try and mitigate the fact that people may gossip about whatever is going on with the person. I mean, sometimes these employers will walk this tight line of, you know, you have a valued colleague who's battling cancer or something and people would like to know their situation, and obviously you support them and things. But at the same time, you can also have other unfortunate situations where people are less sympathetic or things are going on. And so when you have this, another good reason to try and centralize this, I think, with your into the HR area a little bit, is to address things like, are we treating this in a confidential manner? Are we treating this in a respectful manner? Yeah.
That's a very good point. So moving on to another scenario in the accommodation context, there can be issues, as I mentioned, with respect to how you treat lengthy leave periods and the potential for other accommodations and the need to engage in an interactive process. There can also be circumstances where an employee who is on leave may make requests that turn into a request for accommodation under the ADA when they're on FMLA or other types of leave, and employers need to be aware of how to handle those circumstances. In this scenario, we have an employee who's out on a 2-month leave of absence, and she asks her employer to send home her files so she can be working from home, or just to ask, she asked to have her files sent to her, And the employer responded that it was company policy that no one is allowed to generally work from home and that she's on leave, so she needs to remain on leave and then come back when her leave is expired. At the end of her leave period, the employee complained that she had trouble reconnecting with her clients. She wasn't able to keep up with her workload and her connections during her leave, and she sued after her employer terminated her for refusing to accommodate her by allowing her to work from home. Believe it or not, there is a case that determined that the employee had a triable issue of whether she was denied an accommodation when she asked not even her supervisor, but her assistant to send home her work files, and the company found out about it and said, gee, no, we're not going to send those files home. The employee sued, and the court determined that there was a triable issue of whether she had made a request for an accommodation to allow her to continue working, even though she had already requested a protected leave period. So that interactive process, if the employee is coming back and making updated requests, you can't simply say, oh, you're out on leave, we're really not going to engage you, that's that. You need to be aware of what they're requesting, make sure you're responding to them and understanding what the scope and parameters of what they're requesting are. And courts have also determined that concerns that non-disabled employees may expect similar treatment does not qualify as an undue hardship argument. So an employer's argument, gee, we don't allow anybody to work from home, that's not really something that we do here, is not a sufficient answer when there's an accommodation request under the ADA. Again, courts will look at the individual circumstances on a fact-specific basis, and there may be a point where an employer can argue we can't accommodate everybody working from home, but you need to look at the entire picture and make sure that if you are asserting that argument, you have the business facts and the documentation to back up the undue hardship argument.
We're down to about 3 or 4 minutes. Maybe we want to hit the 10 points at the end
Sure.
and leave some time for questions.
That sounds good. So we've got multiple other scenarios in here. In particular, I'll point out one related to migraine, headaches, and intermittent leave, which is often a thorny issue. And I'll just point out there that medical certification, beginning on page 63, is a key friend of the employer in that context. Making sure you clearly circumscribe what the parameters of intermittent leave are is helpful there. And we're just going to jump to the top 10 takeaways beginning on slide 73. Again, making sure you adopt clear policies with notice, certification, and call-in requirements, plus the consequences for those violations. Under the FMLA, employers need to communicate to employees what the consequences will be if they fail to submit paperwork, fail to follow through with notice requirements, so on and so forth, in order to take adverse action. So get all of your policies up to speed so that you can use them as tools to help manage leave processes. Be aware of circumstances that might provide constructive notice of the need for leave. Obtain clear certification stating the scope and duration of all leave parameters. Again, for intermittent leaves, how long is the intermittent leave going to be needed? How many specific hours or days per month is the intermittent leave anticipated to require? And that way, if the employee is exceeding the medical certification requirements or taking leave that seems inconsistent with the medical requirements, the employer has the opportunity to follow up and then can proceed with discipline if the paperwork doesn't match up with the leave needs. Carefully track intermittent leave use. Follow up where the timing is inconsistent with certification or suspicious. For example, I had a circumstance once where a client had an employee on leave who claimed that she had a back issue and then found out she had gone backpacking during her leave period. So the employer was able to follow up. The medical certification wasn't consistent and disciplinary action could be taken. Make sure to think about how all of the various leave options intersect with one another and work together, and explain in your policies how they work together. When considering evidence of undue hardship related to leave as an accommodation, again, look at all the individual facts and circumstances and be prepared to come forward with metrics and documentation to show what that burden is. Engage in a thorough interactive process prior to discharging any employee on medical leave, even if the leave seems like it's going to be clearly outside the bounds of what would be reasonable, or if the leave is indefinite, ask if there are any other options to bring them back to work before a separation. And again, do not use leave or attendance issues as a way, an easy out for addressing other performance-based issues.
And I'll just add on to that, and as you're going through all those other top 10 takeaways, you're also, I hope, thinking about how are the benefits that are being provided to this employee being impacted by this leave? Obviously, the more an individual has difficulty either because they don't have the proper health coverage, or because now they have a loan that's defaulted, or the other problems that arise from that, you can create a very disgruntled person in some ways when you weren't even thinking about it or you could avoid that if you are thinking about it. So it's important to think about how those benefit issues interact as you're going along. We have a couple minutes left for questions before we give you at least a few-minute break to stretch and stand up here. Does anyone have any questions they'd like to ask? No? Well, as Marilyn kindly noted, she'd put a number of additional examples in there, and especially I commend you to that intermittent leave example. I think both of us have found intermittent leaves are the most difficult ones for employers to tackle, so hopefully that's a helpful example. Thank you all very much for your time.
Thank you very much.